Rapid innovations in the field of information technology, including advanced computing, but also nanotechnology, could result in weapon and equipment advances that may transform the conduct of modern warfare. The right of states to choose means and methods of warfare is not unlimited. International law includes both general rules and treaty law that prohibit or restrict specific effect or types of weapons, means and methods of warfare. International law, specifically Article 36 of Additional Protocol 1 of the 1949 Geneva Conventions, imposes an obligation on states to conduct a process often referred to as weapon review or legal review or Article 36 review to assess the lawfulness of all new weapons, means and methods of warfare. Conducting Article 36 reviews is a necessary step to ensure that a state's armed forces are capable of conducting hostilities in accordance with its international obligations.
The material scope of Article 36 is very broad. The ICRC has interpreted the phrase weapons, means and methods of warfare in its broadest sense to include all types of weapons, be they lethal or non-lethal, as well as weapons systems, and also the way in which the weapons are to be used. Article 36 requires the reviewing authority to take into consideration all relevant rules of international law, particularly international humanitarian law. In relation to international humanitarian law, that means taking into account rules that apply generally to all weapons, as well as specific rules that apply to specific weapons.
The ability of Article 36 reviews to control the development of future technologies could be undermined by a number of challenges. The first one is that there is only a very limited number of states that are currently known to have a formal review mechanism in place. The second one is that Article 36 does not provide any concrete guidance about how states should formalize the review process. It means that the review mechanism may differ from country to country in terms of format, methods of working, mandate, but also level of authority. The third challenge is that states may also be unequally equipped to comply with the requirement of Article 36. States might not always have the resources to fund or the expertise to conduct the review, for instance, of complex and high-tech weapon systems.
Technological changes have actually brought quite a few challenges for Article 36 reviews. One of them is that it's forcing us to readdress concepts that were fairly standardized in international law. For example, what is a weapon?
The difficulty comes when you think of the things that states are actually using, like capabilities that affect the flow of information or manipulate data, or maybe have an effect on operating systems of devices that control utilities without destroying them or damaging them, but maybe just disrupting the flow of electricity or pipelines for some period of time. Those don't necessarily fall easily into the definition of weapons, and so reviews of those can be quite tricky.
Another challenge that's raised by technological change is the level of expertise and the variety of expertise that's required by legal advisors and weapons reviewers. Traditionally, they would need to know about explosive yields of munitions, about damage tolerance of various materials. Now legal advisors don't have to become experts in, but at least have to have some knowledge of neuropsychology, of computer science, enough to be able to understand the materials that are handed to them by developers. And this is a huge change from the way that it used to be.
I think from New Zealand's point of view regarding Article 36 and trying to simplify the complex area of law that we're talking about, or even complex technologies that we're talking about here, is a challenge for the armed forces, because in doing Article 36 reviews and implementing new weapon systems, we really have to have it as simple and clear and concise as possible. Of course, coming from New Zealand, we're one of the larger countries in the South Pacific, so in terms of Article 36 reviews, a number of the countries are a lot smaller than even the tiny country of New Zealand. I'm thinking of countries such as Samoa, Cook Islands, and even countries that don't have a defence force but do contribute to military outcomes and defence outcomes, and they don't probably have the capacity, capability or knowledge or understanding of Article 36 reviews.
The Department of Defense is looking at how to adapt its testing to accomplish what we need to accomplish for weapon systems. And part of that is, how do we look at sort of emergent technology? How do you test for that? And I think with any sort of system, you have to have the appropriate testing. And the Department of Defense has looked at this again, and one of the conclusions was that you are not going to be able to test these new systems with autonomy and weapon systems and cyber in the same method that you would test an M16. They're just very different.
In light of the technological changes, it is essential to create the conditions of a more widespread and robust compliance with the requirement of Article 36. Increased transparency on weapon reviews procedures could become a virtuous cycle in many regards. It would allow states to demonstrably prove their commitment to legal compliance. It will also be of assistance to states that are seeking to set up or improve their weapon review mechanism. In addition, it could contribute to the development of point of guidance for the implementation of weapon reviews, which would reinforce international confidence in such a mechanism.
I certainly think it would be useful for states to be open about the way they do their weapons reviews. And in fact, I don't know what would be the problem with them being open about the way they do their weapons reviews.
If you can create a process that other states can emulate and each of those states do those across the board, I think that increases the reliability of those systems and also the public confidence that those systems are being reviewed properly.
We encourage all states to share information about their legal review mechanisms and, to the extent feasible, about the results of legal review processes, particularly where problems arise with IHL compatibility. Greater transparency can help to identify good practice and ultimately assist states who are wishing to set up or develop their own review mechanisms.
And I think for enhancing and ensuring compliance, it's really an education process that needs to happen, particularly for those countries that have signed up to Article 36 or Additional Protocol 1 in particular.
Additional Protocol 1 doesn't specify how each state is required to conduct legal reviews, and there is no one-size-fits-all approach. It is up to each state to determine what mechanism it puts in place in order to comply with Article 36. However, on the basis of the existing and available practice of states and on the ICRC's own commentary on Article 36, the ICRC has developed a guide to assist states in setting up or improving mechanisms to review the legality of new weapons, means and methods of warfare.
I think it's important that we sit together and talk to really understand what the problems are and how to approach them. Even though we don't always agree upon the things in the same way, we get some reflections in which we can bring back to our own national review, which we are responsible for setting up.
I think one of the important things to do are processes like this SIPRI conference that's being organised, where legal practitioners, where academics, where researchers in the field can come together and can discuss in generalities the legal issues that are raised by Article 36 reviews and particular technologies.
I think conferences like this is important, but I also think that states need to meet and have their own type of area in which they discuss what are their obligations, how can we bring it on, and share some of the ideas and the information on legal reviews that has been done, so that we understand what to look for and in that way improve our national systems to be better. I think that is important to spread what we are doing to create that openness.
I mean, at the end of the day, the very core problem or the core issue is how can we ensure that existing law or regulations or mechanism that we have to control developments in the field of military technology are adequately equipped to cope with the pace of technological change.